Where I believe that SCOTUS could potentially review the case is under federal question. The reason for it is that whenever you have a bank loan, there are federal laws that are associated with it. And Trump's legal team could bring the case up to the Supreme Court saying, hey, the state of New York, including all the way up to the state of New York's highest court, wholly ignored the federal aspect of the business loan that was obtained in order to, make wholly state decisions. Because there are federal issues with this case is ripe for a federal question for you to review whether or not this taking that the state of New York is attempting to do is unconstitutional. The other issue is under constitutional issues, preemption, and adequate independent state grounds. So the constitutional issue in this case is a taking, meaning that the state of New York is trying to take property, including money from Trump. Trump's team is likely to argue that the state court is breaching his constitutional rights by arbitrarily finding and attempting to take his property in lieu of facts that show that Trump was above board throughout the loan with Deutsche Bank. As an aside, the loan was actually paid in full, making this case even more interesting from a constitutional standpoint. Preemption. If you have ever taken out a loan, you will find that there are aspects to the contract that meet both state and federal law. For example, federal regulations in bank loans, including the Truth in Lending Act, Equal Credit Opportunity Act, Fair Credit Opportunity Act, etc., etc., etc. This is not an exhaustive list. Because the loan would have federal regulations tied to it, Trump's legal team could potentially appeal the case to SCOTUS under preemption. Under the doctrine of adequate and independent state grounds, there are cases that would favor Trump's legal team. Now, I do think that this would probably not be the first thing that their legal team is going to argue. It would be more down towards the bottom of like, these are, some other aspects of the case that, should be ripe for the Supreme Court to review this. So in Oregon v. Haas, which is a 1975 case, the Supreme Court held that the adequate and independent state grounds doctrine does not allow a state procedural rule to preclude consideration of a federal question that is properly presented. So, hey, Supreme Court, we have federal issues in this case in addition to the state grounds, and the state never reviewed the federal grounds. We are asking you to review the federal grounds. The second is DeSys v. United States, and this is a 1969 case. The Supreme Court explained that when a state law ground is so intermingled with federal law that the state law claim is not independent of the federal claim, the Supreme Court can review the decision. Again, this case is about fraud on a loan application that has both state law and federal laws that are tied into it. They're intermingled. And Judge Enderon didn't really make a determination regarding it. He was more focused on the fact that state law allows for the state of New York to take from somebody if they can show fraud, which I'm not going to really discuss it in here, but proving fraud is a very high bar. And I don't think that was made in this case either. So what this all means is, in this case, is that Trump's legal team could argue that state grounds for ruling against Trump precluded the federal questions. Because the bank loans also have a basis in federal law, they're all intermingled, it's not independent, and it's ripe for a federal claim.